70?
70.
Yes.
May I place it, Lord?
Yes, please.
The governor is pleased to introduce the following scheme to provide, kindly underline this, limited livelihood, support and social security on humanitarian grounds on purely temporary basis, subject to consequential orders of any competent court, to distressed families of non-teaching staff in Group C and Group D categories who were recruited through 2016 selection process conducted by the West Bengal School Service Commission and who have lost their jobs and whose salaries have been discontinued for reasons beyond their control as a consequence of court proceedings which are yet to attain finality, as on the date and where review petitions are pending before the Honorable Supreme Court. Now, this presumption is absolutely preposterous. Then, whereas the state government, along with the West Bengal Central School Service Commission, have already filed respective review petitions before the Honorable Supreme Court seeking review of inter alia the judgment and order dated 3rd April 2025 passed in civil appeal number so and so, with which appointments of Group C, Group D itself staff made pursuant to the 26th recruitment process were set aside. But these were set aside on the ground of the corruption. Whereas by reason of the said judgment, several thousand persons have been rendered jobless overnight, affecting their right to life and livelihood. And whereas the Constitution envisages the state to be a welfare state, where preservation of life of every citizen, every person, especially where it has been jeopardized due to reasons beyond their control, is essential for the welfare of the society. And whereas Article 21 of the Constitution of India enshrines right to life as a fundamental right, the obligation to protect which squarely rests with the state, especially in case of matters of public employment, and Article 41 of the Constitution of India also enjoins upon the state, within the limits of its economic capacity and development, to inter alia provide public assistance in cases of unemployment or old age or sickness and disablement, or in other cases undeserved one. And whereas it's a matter of record that Group C, Group D staff were employed under the state and whose employment has now been terminated by an order of court where the state was a party. And whereas the duty of the state to take appropriate measures to ensure that such persons are not deprived of the right to preservation of life overnight, and that such persons have a minimal amount of time to make a suitable alternative arrangements to ensure their livelihood. And whereas it has been done by the state in the past on temporary basis and subject to any consequential order as may be passed by competent court of law, state has formed an opinion to provide support to enable such persons to apply for alternative means of livelihood within a minimal amount of time, and therefore the scheme herein below is formed. And whereas the scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families or non-teaching staff in Group C and Group D categories until the final adjudication of the review petition of appropriate application filed with the Honorable Supreme Court, or any further petition as may be filed in accordance with law until proceedings attain finality. But the basic perception of law is not vitiated. Filing review does not disturb the finality which has been delivered by the judgment. Now, therefore, in exercise of powers under Article 162 of the Constitution of India, governor is pleased to frame this scheme. What the distressed families? And this will come into effect from 1st April 2025. Distressed family means the immediate family of any non-teaching staff in Group C or Group D category who was recruited through the 2016 selection process conducted by the West Bengal Central Service Commission, constituted under so and so. I am not troubling my lot with that. Then kindly come to the next page. Registration to avail benefits under this scheme, and eligible non-teaching staff in Group C or Group D category who belonging to a distressed family must supply application, this and that. And benefits of the scheme. An eligible non-teaching staff in Group C and Group D category belonging to a distressed family shall be entitled to receive cash assistance of 25,000 and 20,000 per month, respectively, as livelihood support. The benefit shall be discontinued upon occurrence of any of the following events: on date of the applicant, on the date on which the applicant attains the age of superannuation, the finality to the illegal appointments. Upon the proceedings before the Supreme Court arising out of civil suits to attain finality through final disposal of the review petitions or any other further petitions as may be filed in accordance with law by the Supreme Court of India, which was earlier, due to any other provision laid down in this scheme by the state government from time to time. This is the scheme. This was wholly without jurisdiction and to support the corruption which was perpetrated by the state itself. Kindly come to know the Honorable Supreme Court judgment. That we have annexed that. Paragraph 45. Kindly turn to page 62. Page 63. This is the conclusion of the Honorable Supreme Court judgments. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the court that services of tainted candidates who were appointed must be terminated, and they should be required to refund any salaries, payments received. Since their appointments were a result of fraud, this amounts to cheating. Therefore, we say no justification to alter the direction. The final direction of the Honorable Supreme Court is the tainted service goes and you have to return the money. Keeping this in mind, state government now engages them to support them out of the public fund. Then 46. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Further, no candidate can be appointed once the entire examination process results have been declared void. Now, these are the two important directions. The rest are not very important. And then kindly come to paragraph 51 at page 65. Our observations and findings would not influence the criminal proceedings. Accordingly, we uphold the impugned judgment, cancelling en bloc entire selection process, but have made certain modifications in the directions issued by the High Court. The appeals are disposed of. Now, thereafter, the state government, my lord, through its agencies, filed an application before the Honorable Supreme Court. Kindly turn to page 66. The application they filed an application. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for classes 9 and 10 and class 11 and 12, not found to be tainted subject to the following condition. Kindly see, this is the application made by the state after the Supreme Court judgment was delivered. An advertisement for fresh recruitment to the aforesaid shall be published before 31st May. The examination of the entire recruitment process shall be completed by 31st December. The state government, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May. Enclosing there is a copy of the advertisement for the fresh recruitment as well as the schedule thereof so far as to ensure completion of the recruitment process. The next part is very important. We clarify that this order shall not be read as a conferring any special right or advantage on the aforesaid teachers insofar as the fresh recruitment is concerned. We are not inclined to accept the prayer in the present application insofar as non-teaching posts in Group C and D are concerned, as the number of appointees specifically found to be tainted in this age group is substantively high. And secondly, what has prompted us to pass this order in respect of assistant teachers not found to be tainted is that the students undergoing study should not suffer. Therefore, on the application by the state itself, the Honorable Supreme Court was very categorical about Group C and Group D, no concession to them. Now, after this, this scheme comes. Now, but the basic duty of all the agencies under Article 144 of the Constitution, Lord Shikani turns to Article 144.
Constitution ছিল না এখানে এটা ফেরত দিয়ে দিন Yes.
Civil and judicial authorities to act in aid of the Supreme Court. All authorities, civil and judicial in the territory of India shall act in aid of the Supreme Court. Therefore, the obligation was that the authorities must ensure that the Supreme Court judgment is respected and followed. Here, to subvert the decision of the Supreme Court, the state government uses its power under Article 162. Now, kindly turn to Article 162. Article 162 is the extent of the executive power of state, subject to the provisions of this Constitution. I have placed in Article 144. The executive power of a state shall extend to the matters with respect to which the legislature of state has power to make laws. But what is the power of state to make laws? To unsettle a Supreme Court judgment or even a High Court judgment? Provided that in any matter with respect to which the legislature of state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution, or by any law made by Parliament upon union or authorities thereof. The 162 also does not empower them to make a scheme to frustrate the judgment of the Supreme Court, where Article 144 makes all the authorities responsible and bound to act in aid of Supreme Court judgment. But another article which might be necessary for consideration, kindly also will turn to Article 282. But this point may be taken, but though after 162 is categorically mentioned, this has no application. Miscellaneous financial provisions.
Which article did you mention?
282.
282. Yes.
Expenditure defrayable by the union or state out of its revenues. The union or state may make any grants for any public purpose, notwithstanding that the purpose is not one with respect to which Parliament or legislature of the state, as the case may be, make laws. Therefore, 282 is an extraordinary power given for immediate expenditure to be made for a public purpose. Now, they did not take recourse to Article 282, they took recourse to Article 162, where the 160 doesn't empower them to prepare a scheme which deliberately and directly wants to wipe out the effect of the Supreme Court judgment. Well, on this premise, I would like to Lordship intervention and stay of this.
41 article.
Article 41 the directive principle of state policy, that also does no help to them. Article 41, which mentioned, says right to work, to education and public assistance in certain cases. State shall, within the limits of its economic capacity and development, make effective provisions for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. None of the provisions that empowers, I would repeat, to set at naught a Supreme Court judgment which has declared that the appointments goes because of corruption. Now, this is the first thing.
Would you like to continue? It's already 1:17. I do not have any objection.
Or could I come back tomorrow, Milord? Subject to your Lordship.
But then have you given effect to this?
Yes, it has been given effect to Milord. I believe, Milord, one installment has already been released.
Order effect or effect?
One installment means it's applicable from 1st of April. So April's money has been disbursed.
No. The notification is issued
Milord, I'll come back with better insight. I'll come back with insight.
Applications are to be called
Yes,
for. It has to be
been
scrutinized, screened. There is a screening process. It will take time. How can it be done so soon?
But I'll take Milord better instruction and come back, Milord. I don't think that I should make any comment on that.
But then please do not distribute the money.
He starts, I have taken his kind leave. May I place? So thereafter, 2 further applications are moved to the Supreme Court.
All right.
Now, I kindly takes up, this is the application, the prayer which was made, not by the state, but by the affecting parties.
কোন অর্ডারগুলো দেখাচ্ছে?
না, ওটা দেখাচ্ছি, তুমি
স্যার এই অর্ডারটা দেখাচ্ছি।
Is it in the same appeal?
Same.
All right.
After the judgment was delivered on 3rd April,
Yes.
17th April, the state application where the modification was to the extent that
Verification.
teachers may be allowed till 31st December who are not tainted. Thereafter, another application was filed by some of the candidates who lost their job.
All right.
This was the prayer made and the order was passed by this court.
স্যার এই যে দিয়ে দিচ্ছি।
Clarify.
আরেকটা
On 23rd of May,
All right.
the Honorable Court passes in dismissing the application. We find no ground and reasons to entertain these applications competently filed for clarification of the judgment and order dated so and so, and connected matters.
All right.
There before, without notice to us, this was notice to us, another application was moved. There also the Honorable Court passed this order. একই order.
23/5 দুটো কি 23/5?
ওই একটা ওই মীনাক্ষী order করলো, একটা বকুল হচ্ছে।
One is on 21st May, one is on the 23rd of May.
Yes. Of different group of And
And
different-
prayer was same for permission to file additional documents, facts, clarification, direction for grant of interim relief, permission to file additional documents. All right.
Therefore, the repeated attempt was made before the Honorable Supreme Court. Honorable Supreme Court did not at all entertain these prayers. In that background, this scheme
Scheme has been formulated. All right.
My lord, first is, my lord, who are before the court. My lord, please have a look to paragraph 2 of the writ petition. 2, 3, and 4. The petitioners state that your petitioners have the requisite qualification for being appointed in Group C and Group D post in any so and so. Then para 3, your petitioner states that the commission published an advertisement for appointment in the post of Group CD. Pursuant to the advertisement, petition number 1 applied for Group C and petition number 2 Group D, and the petitioners participated. Then para 4, the petitioner states that the petitioners were placed in the waiting list. This is very important. And soon thereafter, the petitioner found that there was large scale, etc. First is, my lord, the petitioners, my lord, were not appointed. They were, my lord, waitlisted candidates. Therefore, my lord, any scheme framed for those who have lost their job, my lord, in my very respectful submission, cannot in any way, my lord, prejudice the rights of the petitioners. Because we are before a mandamus court. We are not before, my lord, any public interest litigation court. My lord, this is my first respectful submission. But the second submission is, where the waitlisted candidates were also before the Supreme Court. But your Lordship may kindly, my lord, have a look at page 29, the relevant portion of the Supreme Court's order. This is the 5th page, my lord, of the Supreme Court's order. Please take the last 3 lines. Other writ petitions were filed subsequently in 2021, seeking individual appointments and alleging illegalities in the 2016 recruitment process. Illustratively, some of the issues raised were, please turn the page, clause number 4 and 6. Candidates in the waiting list for Group D post in the panel published on 26/2019 were ignored, and a new notification dated etc. has been published, initiating a new recruitment process. And 6 is, candidates neither in the merit list nor in the waiting list were appointed and also joined in the school. Then, my lord, may kindly take, my lord, the later part of the Supreme Court's order, my lord, the internal page 35 at running page 59. Para 36. Apart from so-and-so not returning mirror copies of OMR sheet, other questions arise. In particular, are the significant discrepancies between the marks in the computer software and the data found on the 3 hard disks recovered from so-and-so. Further, commission did not upload the marks of the candidates while uploading the list of candidates called for interview and included in the panel as the wait list. Marks were only displayed after the High Court's order dated so-and-so mandated disclosure of marks. This omission appears deliberate, likely intended to conceal the marks of candidates on the wait list, raising concerns about the potential data manipulation, etc. So, my lord, the wait list candidates' concerns were also, my lord, projected, canvassed, and, my lord, looked into by the Supreme Court. And finally, my lord, what order has been passed is that this Honorable Court's division bench order was upheld by the Honorable Supreme Court. Therefore, my lord, my respectful submission is, number 1, that, my lord, the wait list candidates, my lord, cannot have any grievance in respect to this scheme.
Yes.
Why? Because, my lord, please take, my lord, para 45, the conclusion of, my lord, the Supreme Court's order, my lord, at running page 63. But whatever, my lord, relief buffer the Supreme Court gave was all to, my lord, the candidates who got appointment on the basis of merit list, whatever was, my lord, the consideration of the Supreme Court. Finally, my lord, no relief was granted to the waitlisted candidates by the Honorable Supreme Court. Please have a look at paragraph 45, 46, 47, etc. 48, 49, and finally 51, which Mr. Bhattacharjee has placed.
So the locus standi of the petitioners
Is number 1. Number 2 is, like a legislation, similarly, my lord, in case of a scheme, my lord, framing of a scheme or enactment of a legislation itself does not give rise to a cause of action for challenging the same. But the cause of action arises only when someone is affected by implementation of the Act scheme, whatever. I give you, Lordship, an example. Say 2003 Electricity Act is promulgated. I am aggrieved by XYZ clauses. Now, my lord, so long, my lord, I don't get aggrieved, take a cause of action. Say I get a disconnection notice in terms of section so and so of the Electricity Act. My lord, then and then only, my lord, a cause of action would arise in my favor for moving the court. Therefore, mere framing of a scheme, mere floating of a scheme, or even, my lord, legislation, my lord, does not give rise to a cause of action. A cause of action arises only when, my lord, it is implemented adversely against the person concerned. So, my second point is, no cause of action has arisen, my lord, for the writ petitioners to move before your lordships. But my third point is, but as Mr. Bhattacharya has placed, there are some beneficiaries under this scheme. Right or wrong, there are certain beneficiaries. None of the beneficiaries are before your lordship, or they have not been made.
Why will beneficiaries come? Because they are the
No,
beneficiaries.
no. I could not explain myself, my lord. What I respectfully submit is, my lord, none of the beneficiaries are respondents in this writ petition.
Respondents.
Yes.
All right.
Therefore, my lord, without
So
the-
you want the 25,000
No,
candidates?
they can always be, my lord, impleaded in representative capacity.
All right.
They can always be represented by representative capacity. I mean, impleaded by in representative capacity. But that prayer has not been made. That leave has also not been sought for.
Very well.
Therefore, my lord, the beneficiaries are not before the court. Number 4 is, where Article 144 is sought to be, my lord, invoked. Where no dispute that all civil and judicial authorities must act in aid of the Supreme Court. No dispute on the proposition, because the article is explicit in that. Now, my lord, the Supreme Court has considered, because my learned friend's submission is that this scheme is to subvert the Supreme Court's direction, or whatever has been done.
Or frustrate the direction
the
of the
Supreme
court.
Court's order. Or I take it to a larger extent that it violates the Supreme Court order. What has the Supreme Court, my lord, opined in such a situation? In such a situation, my lord, the Supreme Court has said that a writ petition is not maintainable, and judicial discipline requires that
They should approach the
Supreme Court.
Said-
Just have a judgment on this, my lord. But this is a case, very short judgment, my lord, where, my lord, some auction was being held, my lord, pursuant to a Supreme Court direction, my lord. A writ petition was filed, and, my lord, the Supreme Court was considering whether, my lord, the High Court should have entertained the writ petition or not. Please take paragraph 4, my lord, a very short judgment. We are rather concerned to note that WP number, etc., has been entertained by the Lucknow bench of the Allahabad High Court. The writ petition is directed against the auction sale of so and so, and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court noticed in the interim order that auction was being conducted under orders of the court, this court, and that the matter concerning auction of the house was pending in this court. How then a writ petition could be entertained in the High Court is not understandable. Judicial discipline requires the High Court not to entertain any such petition when the proceedings are pending in this court in respect of the subject matter of the case. The parties should have been asked to approach this court. If so advised, the High Court said had no jurisdiction to entertain the writ petition in the fact situation. We need say nothing further on this aspect except to record our displeasure. This order shall be brought to the notice of the High Court. Therefore, my lord, my next obligation is to demonstrate before this court that where the Supreme Court had passed an order, certain ancillary direction, as my learned friend has also placed, has been passed. The review application is pending before the Supreme Court, where the Supreme Court, my lord, will take a call on that, my lord, whatever is the. Now, my lord, when, my lord, the submission is that the Supreme Court's direction is sought to be subverted, or as I have said, I take it to the highest extent that it has been violated. In that case, my lord, the Supreme Court, noting, my lord, Article 144 was of the view that, my lord, it should be left to the Supreme Court, and, my lord, writ petition should not be entertained. Well, there was a development in the matter. The other development in the matter was, my lord, certain persons, but after, my lord, the order of the division bench of this court was upheld by the Supreme Court, my lord, some persons had moved the division bench of our High Court subsequent to the order of the Supreme Court, seeking implementation of, my lord, the directions of the honorable division bench and the Supreme Court, which was ultimately, my lord, upheld by the Supreme Court. Now, my lord, there, my lord, kindly have a look to it what, my lord, our division bench had, my lord, said. This is, of course, my lord, in the contempt jurisdiction. Instead of, my lord, taking your lordship through the order in its entirety, my lord, all the judgments, my lord, on both aspects, my lord, whether to execute or not to execute, contempt, not contempt, etc., my lord, was considered. And finally, my lord, your lordship may kindly come to, my lord, paragraph 47. which is page number 26 of the judgment. This is our division bench. An order passed in the writ jurisdiction is enforced through a contempt proceeding primarily on the principle that non-adherence or non-compliance of the writ issued tends to degrade his dignity and majesty of the court issuing the writ. In the facts and circumstances of the present case, the ultimate writ was issued by the Honorable Supreme Court, and therefore contempt petition would not lie before this court to enforce such an order unless specifically empowered by the Supreme Court to do so, akin to Dination KK Supra. Consequently, in the absence of the provisions of the Code of Civil Procedure, to execute an order passed by a writ court, the analogy of the principle that even if the ultimate decree is modified or altered and affirmed by the Supreme Court, the same needs to be executed. Then, Miller, Article 215 is considered by the Honorable Division Bench. Next, kindly take paragraph 50 onwards, where Miller, our Division Bench, Miller, takes notes of the doctrine of merger, Miller, at paragraph 50, 51, and 52. Then paragraph 53, in the facts and circumstances of the present case, there are 3 orders of the Honorable Supreme Court. Subsequent to our judgment dated, etc., Supreme Court dealt with 2 sets of appeal. Then third order is dated so-and-so, and a miscellaneous application filed in one of the sets of appeals before it. The last order dated 17th April of the Supreme Court contains certain directions, etc. And Miller, the last sentence at paragraph 54, such order also contains a default clause in the case of non-compliance of the directions contained there. So, Miller, everything is being monitored by the Supreme Court, and in paragraph 56, in view of the directions contained in the order of 17th April, it would be safe to infer that the Honorable Supreme Court is still in ceasing of non-compliance of the direction. Therefore, Miller, the division bench is also, Miller, is of the view that the Honorable Supreme Court is in ceasing over the matter. Therefore, Miller, assuming for argument's sake, Miller, that the writ petitioners, Miller, have a cause to, Miller, interject, Miller, the framing of the scheme or implementation of the scheme, Miller, my respectful submission is, Miller, when the Supreme Court is in ceasing over the matter, and, Miller, even going by, Miller, Article 144 of the Constitution, Miller, but as the Supreme Court said, Miller, in the judgment which I have handed up, Miller, the parties should, Miller, approach the Honorable Supreme Court. And waitlisted candidates were before the Supreme Court. It's not that they were strangers in the Supreme Court proceeding or before the High Court. Therefore, Miller, these are, Miller, primarily, Miller, my submissions, and, Miller, no argument has been made that the state is legislatively powerless to frame this scheme. Because 162 says that the executive powers extend to the extent of legislative powers. So no submission has been made that the state is powerless to legislate on this topic. Of course, it cannot be, because Article 41 has been referred to. Rightly or wrongly, it has been referred to, Miller. Therefore, Miller, in the absence of, Miller, any submission that the scheme or the legislation is expressly unconstitutional, but in my very respectful submission, Miller, it doesn't call for, Miller, any interim order, Miller, provided, Miller, my points of demur are not accepted by the court. Therefore, Miller, in order to, Miller, pray for an interim order, Miller, one has to show that the legislation or the executive order is expressly unconstitutional. But that no submission has been made. The submission is that Supreme Court order is sought to be bypassed. And when the Supreme Court has taken note of that in such a case, the Supreme Court is capable enough to take care of its order to be complied with or violated, or to act in aid or acting the horse aid of the Supreme Court. The Supreme Court will take care of that. And we have two more sentences, my lord. One is, my lord, a number of review applications are pending before the Honorable Supreme Court. And number two is, my lord, the scheme itself is, my lord, interim in nature. May I place, my lord, those portions? Mr. Bhattacharya has placed those, but please have a look to, my lord, page 70. Please take the last recital at page 71. And whereas this scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families of non-teaching staff in Group C, Group D categories until the final adjudication of the review petitions or appropriate application by the Honorable Supreme Court. Then, my lord, your lordship may kindly take, my lord, the page 72, paragraph 6 of the scheme. First is, my lord, an eligible non-teaching staff in Group C, Group D belonging to a distressed family shall be entitled to, etc., as livelihood support for his or her distressed family due to sudden unemployment and on humanitarian grounds with effect from so-and-so and whose salary has been discontinued. The benefit shall be discontinued upon occurrence of so-and-so, so-and-so. Any of the following, whichever is applicable or occurs earlier. Of which, my lord, item number I is, my lord, conclusion of the Supreme Court proceeding. Yes, and 5 is, my lord, on securing some other livelihood. Therefore, my lord, the scheme itself is, my lord, interim in nature. Scheme refers to the Supreme Court review petition. Scheme again says that it will come to an end once the Supreme Court takes a final call on the review applications or whatever are pending.
Tell me one thing.
Yes.
The amount has been fixed at rupees
20 and
25,000.
25, yes.
20 and 25,000.
Correct.
How did you fix up this figure?
But I think it is for the C, it is.
So the salary amount you've taken as the base rate or something.
But on this, right now, I'm not in a position to assist you.
And how many candidates' jobs were set at naught by the order of the Supreme Court? Who will be the beneficiaries? The figure?
C and D.
And page 71,
Yes, ma'am.
the third recital
Yes, ma'am.
mentions about a similar incident in the past.
Yes.
What are such similar incidents in the past where the financial benefit has been granted
Well,
to?
there has been a lot of instances, may not be for relating to employment. To my knowledge, say for example, my lord, puja donations.
No. Those
Say
are
for
separate.
example- Yes,
Those
no,
are separate.
these are because 282, my lord, the attention of the court has been drawn to 282. Therefore, my lord, I am saying, my lord, these are all, my lord, come, my lord, under different heads from the consolidated fund, and my lord, different separate account numbers are required to be, my lord, maintained. And there's another judgment, but right now, my lord, I don't recall where, my lord, our High Court has held in regard to the expenditure from the consolidated fund. It is not for a judicial review by a writ court. I'll get that judgment because I was possibly, my lord, addressing the division bench on that. In a PIL, my lord, that was held.
Regarding the
financial expenditure.
honorarium granted to the
Very many
Muslim,
was there. Very
to the
many
Muslim priests or something.
Yes, yes, yes.
There is
No.
one order,
Yes, yes.
right? But tell me, so you are not aware as to why this 25,000
20
has,
and 25.
and the assistance that you will be giving to these people, will these people give anything in return, or they'll sit at home and they'll earn the money?
My lord, here, my lord, because of, as the scheme says, because of sudden loss of livelihood.
That means somebody will stay at home and you will go on paying the money till the Supreme Court decides an issue.
But this
And
kind
how long will the issue be said to be pending before the Supreme Court? Because one after another review petitions will come. There will be no end. You cannot stop anybody from filing a review
that is for,
application.
my lord, the Supreme Court to consider how long, my lord, Supreme Court will entertain.
And no,
Supreme Court
your
will not
petition
entertain me
says, no, your petition says it will continue till the matter is pending.
No, still, my lord, this review applications, my lord.
So one after another review applications will come.
No, my lord, please have a look to, my lord.
Second paragraph, filed review petitions before the Supreme Court. Central School Service Commission has filed review petition. Right.
No, it's only, my lord, the state government, the first recital. Please have a look at page 70.
Yes.
The state government, along with the School Service Commission, has filed respective review petitions before the Supreme Court.
Yes.
Yes. So it is only, my lord, the review applications which has been filed by the state and, my lord, commission, which is taken note of in this scheme.
No, but then what will be your submission with regard to paying 20 or 25,000 rupees to a whole lot of candidates who are sitting at home and not doing any work? Public, you are spending public money for it.
Yes. Yes.
And to candidates whom the Supreme Court has specifically
Not to
use
prejudice of-
the-
May I say this? Yes, I got your lordship's point. My first response would be, Milord, that Milord, at the instance of Milord, the writ petitioners, Milord, with respect, Milord, kindly do not take me amiss. Possibly, Milord, this point cannot be raised by the petitioners. That if I am not getting, why is he getting?
No, he is not getting his waitlisted, no question of
Therefore,
it.
Milord, if he or the petitioners over here cannot get, then Milord, the petitioners does not have a cause to pursue before this court.
So you want somebody who were there in the Supreme Court to come here and challenge this? Who could be the, according to you, the challengers to this scheme?
Milord, may I say this, Milord? Today, Milord, we are concerned about the writ petitioners. But if the writ petitioners either have a right or they don't have a right. If they do not have a right, Milord, then whether tomorrow somebody will come or somebody comes at my liking is something different. If they do not have a right today, Milord, in my very respectful submission, Milord, this petition cannot be
Maintainable. All right.
entertained. Because, Milord, your lordships have held, Milord,
Yes, sir.
mandamus is, Milord, for infringement
Anything
of an established right.
Anything in reply?
No, 1995
1995
যেটা ও রিলাই করলো
99.
99 না the deepest of respect not learned advocate general probably
The first demurrer was locus standi. It is not a pill, it's a writ petition.
this writ petition by a person who was a candidate after cancellation of all appointment method, all persons come to the same footing. There you cannot make a classification. That's the first point Milord, for a writ petitioner, which comes under Article 14. I am not, therefore the locus standi petitioner Milord, cannot be questioned at all.
Very well.
Secondly, one important aspect which you wanted to raise kindly takes up 1999 5 SCC. I have not cited judgment, but if necessary, there are judgments. I will cite it, but let me rely on his own judgment, which is relied upon. First of all, this has no 141 application. Kindly first,
144
no, 1999 5 Supreme Court case is page 733 does not decide any law which has binding nature to this court under Article 141. What does the court say? Let us see. May I just place it? Paragraph 4. We are rather concerned to note that the writ petition number such and such has been entertained by the Lucknow bench of the Allahabad High Court. That writ petition is directed, kindly see, against an auction sale of house number such and such and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court has noticed in the interim order that auction was being conducted under the orders of this court, and the matter concerning auction of the house was pending in this court. Therefore, the question of amity of judicial discipline comes. In our case, this is a new cause of action. You prepare a scheme after the judgments have become a concluded effect. Mere filing of review application does not legally entitle somebody to say that the
List is pending.
only after the review notices are issued, and the lordship knows as so from my experience I can tell you, lordship, the Supreme Court review applications are not hard. This is decided by the honorable judge in the
Chamber.
That's why they use this method of filing MA applications, and which have been repeatedly dismissed by the Supreme Court. That indicates the Supreme Court has reached its final conclusion. After that, this scheme, Article 162 does not empower you, I have argued this, to negate a judgment of the Supreme Court in any manner. The judgment declared by a court can only be changed by way of a legislation removing the foundation of the judgment. That is the settled principle. I don't have to argue. Even in this court, we had got the Cooperative Societies Act ultra-virus declared. Then they passed a legislation taking out the grounds on which this was declared to be ultra-virus and passed another law, which is also under challenge. That's a different thing. Therefore, that is the settled law. Therefore, 162 does not empower you to legislate in the form of executive action to negate a Supreme Court judgment or even negate a High Court judgment. And this scheme is specifically maintained for the persons who have been found to be corruptly appointed. Can the state, in any form, giving in the name of relief, support corruption? This is the first question. The second question was that not only they have been found to be corrupted, this direction of the High Court to upheld by Supreme Court that they have to return the benefit of money which they have earned so long. And instead of getting the money returned from them, you are trying to support them out of public fund. This is the question of the constitutional morality again comes in. And in this context, Lord, I would like to cite one decision of the Supreme Court where the then Chief Minister of UP, Mr. Mayawati,
106. 106.
2012 8 SCC 106. Here, my lord, the CBI started an investigation saying that the Supreme Court directed. The petition was filed. From that, it went up to the Supreme Court. Supreme Court says entire thing is squashed because you cannot take, in the name of Supreme Court, start doing something which is not under the order of the Supreme Court. This is the basic principle of this judgment. I just kindly place before Lordship, my lord, the relevant portions.
Citation বলুন
2000 और लिखे रहता है 2012 8 SCC page 106. After discussing everything in detail, now the Supreme Court says 41, kindly come to paragraph 41. We finally conclude that anything beyond the Taj corridor matter was not the subject matter of reference before the Taj corridor bench, that is the Supreme Court bench. Since the order dated 18 September 2003 does not contain any specific direction regarding lodging of FIR in the matter of disproportionate assets case against the petitioner, CBI is not justified in proceeding with FIR number so and so. In view of the above discussions, we are satisfied that the CBI exceeded its jurisdiction lodging in FIR in absence of any direction from this court in the order dated so and so or in any subsequent orders, and then ultimately squashed. Here, my lord, I have been facing repeated orders of the Supreme Court saying, no, we are not interfering 3rd April. And by repeated application, as it is also mentioned in the scheme, the review applications filed by the SSC and in future it might be filed. You are adopting very unfortunate tactics to waste public fund to protect the corrupt people. That everybody has jurisdiction, and because the read court, where the fairness of the administrative action, Article 14 is very important.
Page 71.
71, kindly turn to page 71. My lord has noticed it, that's why I was referring to.
And whereas. Second last and whereas.
And page 70, and whereas the scheme aims to provide interim relief by of livelihood support and social security. Livelihood support, social security under Article 41 does not remain to a particular group. On humanitarian grounds, to the aforesaid distressed families of non-teaching staff in Group C and Group D categories until the final adjudication of the petition and appropriate application filed before the Supreme Court or any other further petition has been filed. Twice attempt was made. And again, will I say, there is no review application pending for consideration. Mere filing with the registry does not entail consideration by the court. In that background, Lord, I would logically stay the entire scheme. My juniors insisting me just to point out to your Lordship paragraph 9
of
the petition, how his locus is maintained.
Stop.
দেখাতে চাইছিলাম আমি লোকাস বলে দিলাম তো তারপরে কোন দেখাবো
very well.
But only one factual correction, because in reply, I am not supposed to say anything. Milord, the submission made by Mr. Bhattacharya that they have to return the salary, but that is, Milord, factually not correct. Kindly have a look at page para 46, page 60, 45 and 46.
Tainted যারা তারা দেবেন যারা
However, Milord, candidates who are already employed need not be asked to refund.
These are for the teachers. The scheme is for non-teaching staff.
না না স্যার এটা বলে দিন
46 does not, Milord, make any distinction between Group C, Group D and teachers.
স্যার নট
আরে খোঁজকে পড়তে দাও না এত ছটফট করে কেন
Those who are already employed need not be asked to refund.
Yes.
Right.
Yes.
So you are not giving money to the candidates who are already employed. You are giving money to the candidates who have been terminated.
But my submission is, Mr. Bhattacharya in reply, that
Yes.
Supreme Court
Refund.
had directed refund.
Yes.
That, Milord,
But paragraph 45 says they should be required to refund any salaries received. Then
but 46, Milord, does not make any distinction between C, D, or will not teach us?
Please,
Very well, very well. You are
whatever the Supreme Court has said, the Supreme Court has said in the order. Whatever,
But one more thing, Milord.
yes.
Mr. Bhattacharya has submitted that filing of a review application does not mean that the Supreme Court is
In CC of the matter.
number one. Milord, the division bench has said that the Supreme Court is in CC over the matter.
Yes, yes, you've
And number two,
submitted that.
Milord, there's a judgment of Justice Rumapal. Milord, I don't remember, the page was 555. That's why I remember the page number. Where, Milord, in the context of a contempt application, Milord, our court held that once something is filed in the department, the court or the matter becomes sub judice before the court. Then, Milord, the court may allow it, may dismiss it, whatever it is. But, Milord, once it is filed in the department, the matter becomes sub judice.
Right.
If required, I can give that judgment. But over here, Milord, our division bench in the context of this matter has said
that
that it is
wasn't correct. That was in respect of limitation of contempt application. That since it is filed, limitation will not run.
Yes, but so yes.
তো ওইটা ঠিক বলেছে লিমিটেশন ছিল কন্টেম্পটে 1 বছরের মধ্যে অর্ডার ছিল বলে ফাইল করলে পরে
And Milord, salary possibly Milord.
anyway,
The salary amount was much higher, Milord, I'm told, than Milord 20,000 or 25,000.
that is
So
basic.
these people will be receiving either 20 or 25 sitting at home.
Basic.
With
Sitting at home.
if tomorrow, Milord, the Supreme Court dismisses the review application, matter ends over there.
Till the Supreme Court dismisses, the persons
that
will
is
be
Milord,
paid.
that is expressed in the Milord the
Scheme itself.
itself. I cannot Milord make any submission contrary to that.
And whether similar type of schemes are extended or thought of by the state in respect of so many unemployed candidates?
No, the Milord,
Only in respect of the candidates whose
unemployed,
orders,
yes.
whose appointments have been set at
The
not by the
Supreme Court,
Very
the
well.
Supreme Court can take care of that, Milord.
No, no, you are the state. You will take care. Supreme Court is not
But
framing
Milord,
the
then,
scheme.
Milord, I have raised, Milord, a legal issue that when it is, Milord, concerning the Supreme Court and in response to the submission
Yes, yes, I've followed it.
that the Supreme Court's order is being subverted, but my submission is, Milord, it has to go before the Supreme Court.
6 বছর হয়ে গেছে
Hearing concluded, CAV.
I'm grateful. Milord.
Affidavit of service is taken on record.
So, I-